So, I've been checking this petition website a little bit since it reopened at the start of this month. Reopened, I think it was actually around Halloween when it reopened, right? And I think, I'm not entirely certain, but I think they started all the new petitions off at 7. Just a minute. 1, 2, 3, 4. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6. Basically 6 digits, but starting with a 7. So I don't know whether we call that 700,000 or what, but I think that they started off with a round number. I'm not entirely sure, but it's looking like it was 7 and then 6 zeros. And the last time, it doesn't seem like today, which is a Monday, that there was that many new published since the day before. And there wasn't that many on the rejected either, petitions list. But the first one that I submitted, right, was 700493. So there was, when I first submitted the petition, like about 3 days after it had reopened, they'd already had 493. So there was 493 petitions being submitted since it reopened. So that probably works out at about over 100 a day. 493 divided by 3 is at least 100 and... So, I mean, probably even, it might be even 1, 2, 3, 4, 50. Yeah, so over 150 a day. And I know that the person was obsessed with that website who's got the Facebook page for petitioning Parliament. He's obsessed with the EU. All he does is petition to get back into the EU all the time. And he must have been waiting for that petitions website to reopen and checking it every day, if not reloading the page like every single day, waiting for it to reopen. He probably was following the Twitter page as well, but I didn't actually know they had a Twitter. I forgot about that. Anyway, so, but the point is this, right? I did some maths. I was looking at the petition numbers which had been allocated to the petitions, and because mine was 700,493, so as they were like checking them and then publishing them or rejecting them, they either publish it or they reject it. I was looking at all the numbers of the petitions which have been published, and I was writing down some of the numbers like 700266 or 700304, right? And also the rejected one. When I actually checked up to 427, right? And mine has actually now been rejected, but I never got an email to say it had been rejected. You're meant to get an email saying that your petition has been rejected, right? If it's been rejected, but I never got that email. And I looked on the first I looked at the rejected list of petitions, and I was looking through them all to see if my petition had actually appeared yet. I looked through all the published ones, and then I looked through all the rejected ones, and then I noticed it was there. I'm like, oh, look, it's there in the rejected ones. And to be honest, I was actually amazed that they'd even put it in the rejected ones, because I got a feeling that they wouldn't publish it, just because they're awkward, like make up some excuse. I was just thinking, what excuse are they going to come up with this time, right? That's what I was thinking the whole time. What I was thinking is, like, I've spent absolutely ages, like, preparing this petition to make sure that I get everything in it and all the words right, that it has to fit into the limitations, right? And then it took me ages to get the 5 signatures, which was a pain, right? And I waited 15 days, right, to get this petition, see what happens if I can get it published. And I'm like, all right, then what's the excuse going to be this time? They're going to say, oh, we don't understand what you're asking, or it's not something we can do, or it doesn't meet our standards. They got all these, like, fake excuses, right? And actually, right, actually, I thought that they might not even publish it to the rejected list because, to be honest, what they're doing now is they've got this policy rule saying that if they don't publish it and it doesn't meet the standards, then they might not even publish it on the rejected list. So, like, no one even knew that it existed. No one even knew that you even submitted it, right? So that, like, effectively, it's like they don't even want anyone to know that, like, anyone even submitted that petition or that it even existed, right? Just like, it's not even, they're not even going to give you the grace of having it appear that they turned it down and have to even give a reason why they turned it down. They just don't want anyone to know that it existed. And I'm starting to think that that's kind of like the attitude of, like, the burning down of Parliament. I'm like, okay, so in 1834, Parliament burned down, and then literally, supposedly, everything was destroyed, all the records. Well, obviously not Hansard, not everything was destroyed. I won't even know what the law is. They'd have to, like, make the law again. Maybe they did that. Maybe like everything was destroyed, and they just, like, decided that we're just going to change all the laws in history. But I don't know. But I'm not sure. I'm not sure why everything didn't burn down. But we lost all the petitions, all the House of Commons petitions, except the ones that appeared in this. Miraculously, all of the session books weren't burned. I think at that point, quite a lot of stuff might have been published, because they're publishing them in the printing press, so quite a lot of stuff was published, Acts of Law in Parliament. But, I mean, they could, at that point, they could have just, we don't know, they could have just completely and totally rewritten history and made it all up again. I don't know. But, maybe not everything was kept in Parliament or in the building. I don't know exactly what happened, but it's all of the House of Commons petitions that didn't actually get read out in Parliament in Hansard have been destroyed. And effectively, after that day, they started throwing them all away. Any that didn't get read out in Parliament and put in Hansard were destroyed from that day onwards after the fire, up till 1947, so they're claiming, and then they started saving them again. So we don't get anything from history, although apparently there is some microfilm going around somewhere that's got some data from them on, which you can get hold of if you look for it. I probably will look for that at some point when I've got time, right? Now, the thing is, that attitude, though, is kind of what they're doing now. They're saying that, if we don't want to run it, if we don't publish it, right, even to let you even try to get it debated, right, then, or even if it's not even worthy of being rejected and not even worthy of giving a reason why they rejected it, then it's poof. So they might as well just burn them all. They might as well like have at the end of the year, like, just burn all the petitions that weren't even worthy of being rejected or even given notice of. It's the same attitude. That's the attitude, right? Even though the Parliamentary Papers Act protects anyone from suing Parliament for defamation or any ill effects from any documents that it officially publishes, but Parliament itself doesn't want to be defamed or doesn't want to look bad or whatever. They're not even using that Parliamentary Privileges Act to its full effect. What's the point in having an act which stops anyone suing Parliament, right, for anything that it says or does? Like if someone says, I don't know, like, Simon Cowell's gay or something like that or whatever, right? Or whatever other joke you want to come out with. What's the point in having a law protecting you from, publishing or saying what you want without being prosecuted if you don't say what you want without being prosecuted. I mean, what's the point? You know, also like Parliament now doesn't want to look bad, but I mean, it always looks bad when there's people, you know, walking around outside it with signs saying, you know, Starmer is a traitor or whatever, or Starmer, you know, is committing treason or whatever is the latest complaint or grievance that they've got. Parliament is always looking bad. They've got protesters outside complaining. I mean, how can Parliament not, you know, with all the complaints that it gets anyway, it's almost kind of like a TV show, you know, just smile. They only want to show like the, you know, always look on the bright side of life, do. I mean, that's what got the world into this mess of all this junk food and pretending everything's okay when it's not. So they could kind of like do this whole game show TV style thing where the world's okay, and then on TV they've got all these little programs where they kind of like, you know, do a little cheeky tune in the background, like do, kind of like naughtiness. It's kind of like they're trying to make, when anything in life is bad or someone steals something or something goes wrong, they play this little, BBC have got this little tune. It's kind of like it's a little cheeky tune, like, it's just a sneaky cheeky tune, which kind of encourages it. I think it actually encourages mischief, you know, and probably that's why the crime levels are through the roof, you know, I won't be surprised. But, you know, you can't, and this is why there's a dilemma now with government. They've hidden the dark side of reality, the dark side of the moon, for so long from normal mainstream TV, although you've got all these programs. It's either all pretend and fake smiles and everything's okay, or it's kind of like the dark side can only be allowed in fiction. So they've got all these murders and all of the like murders and the deaths and the horror is only in the fiction. So they let it in the movies, and they let the horror in a drama, and they let the horror in, like, you know, Friday the 13th or in a big movie. But apparently on normal TV, like game shows and, you know, Jeremy Vine and you know, X Factor and all these other programs, you know, it's all positive, you know, or you're not allowed on, or you get kicked off, or whatever, you know, and it's not so everything that's the dark side can only be allowed through fiction. So what he's trying to make out, really, the juxtaposition of it is that all that dark side is fiction, you know, when actually the reality of it is it's very real, and that's why people are depressed and why there's crime. But yet, you know, and it comes out in the news as all these, you know, the news actually dramatise it. You should open the newspaper and then everything should tell you what's happened in small print, in equal. There shouldn't be like a cover story. But what they do is they dramatise it and make it, and all the things that are bad are just, there are loads of things happen bad all the time. But what they do is they draw them out into these huge, dramatise it like they do on the movies and TV, right? But when it comes to normal telly, like, you know, calendar, the news at 10, I mean, not news at 10 for, like, you know, things that have gone wrong, but I mean, like, you know, calendar or, you know, morning TV or whatever, it's kind of like they separate it. It's like either all good, right, and or all completely, you know, over dramatized bad stuff. Or so, in fact, what it does is it turns the bad things into life. When it covers, all the movies are like a fake and pretend. And when I said that, okay, they do some bad things in real life, but it's in the news, well, what it does is, rather than it just being a normal occurrence that happens with everything else, right, they turn it over-dramatise it into like that Southport thing or whatever, they make into these kind of like they just kind of like over publicise and play it. And I think that's the thing. And I think trying to get back to the point with this whole video is that Parliament, they don't really want, they're trying to, they want to try and keep this clean image, but the government have never had a clean image. Doesn't exist. I mean, look at history. History happened. The Civil War. James II, being turfed out and chucking the seal in the river, or and William the Orange invading, William the Conqueror. There's no such thing as bright and normal. So I don't know who they're conning or who they're tricking to reject these petitions. The whole point in a petition is meant to be that there is some grievance or wrongdoing, or somebody's had something done wrong to them, or something's not right with the country and it needs to be put correct. Because people are suffering from it, whether it's taxes or a law being too, unjust or whatever. And now all of those petitions actually existed, and it's a legitimate thing to petition the government over. And now they've kind of like shed all that. So now it's only about making or changing laws effectively. But it's not just meant to be about that. It's meant to be about all kinds of different, particularly grievances, begrudgances against the government, Anyway, so yeah, the rejecting, how I got onto that massive tangent was through all the petitions that they're rejecting, and there's not even any existence of them. So what I did was, getting back to the point, 17 minutes later, I started looking at all the numbers, and I looked up to what the latest one was that they approved. And the latest, and when they'd approved number 700,427, at that point, I'm like, well, there's been 427, there has to have been at least 427 submitted at that point. So what I did is, when there were 400, when I noticed that one of the newest ones that had been published at the time, which was a couple of days ago, at 427, I counted how many petitions were actually published at that point and how many had been rejected. And if you counted all the ones that had been rejected, right, I think it was like 66 petitions had been rejected at that point. And I think there was 50. There was how many were published? Oh no, sorry. There were 63. There were 63 published and 30 rejected at that point, right? So if the 63 published and 30 rejected, that means, right, that there were 353 completely unaccounted for. That means there were 353 petitions that didn't even appear on the rejected list. So they weren't published, but they weren't even appearing on the rejected list. 353. Were they really that bad? Were they really swearing or effing and blinding or, calling Keir Starmer names or really asking for things that the government couldn't do, or really ridiculous things that like the Monster Raven Looney Party have got in the manifesto, or really that questionable? 353. Now, there is a possibility that there was 353 that people hadn't yet managed to get the 5 signatures for, because it's hard to get those 5 signatures, I think, even if you've got friends and even if you're in big Facebook groups, just because it is. and people usually can't be asked, or the people who can be asked are the people that you usually ask when you do it, and they get sick of you asking them, right? Unless you're like one of these women, like in one of these champion campaign groups, who literally does everything that you say, like little dogs, like stand, sit, lay down, roll over, like women who have got, command of, 100,000 people in Facebook groups, and, if they say, donate to someone's got cancer charity, then everyone donates, £10 to it. Or if they say, stand, everyone turn up at, like Extinction Rebellion, everyone turn up at Parliament on Tuesday at 4 o'clock, and like everyone turns up. Those sort of people, right? Those sort of people, they don't have any problem getting the 5 signatures, because, if they say, sneeze, everyone will fucking sneeze, right? But the things that they ask for, usually, it doesn't necessarily get them anywhere, because look at the Wales petition, 500,000 people nearly signed that, not far off, and they're still having trouble with it, with the government, so... And actually, all of the Euless petitions added together add up to about 500,000 signatures. In fact, the petitioners committee have just debating one, right? That I think only got 53,000 signatures. They didn't even get the 100,000, which they said you need to get, and they're debating it now. And is that unfair when they've issued a statement to say that you've got to get 100,000 to debate it? Anyway, so what I was thinking is that if the petitions committee is only just reopened, what I thought is this: if you've been waiting for it to reopen, or if it has only just reopened, it's quite a big deal, right? Because it's been, the government started quite a while ago, right? So what I thought is, all of the people who have submitted petitions, right? They must have been either waiting, or they must be quite keen, right? They're not like people who would just like write it and submit it and then like not bother to collect the 5 signatures. Some people will not bother or find it hard, but I thought because it's only just opened, I thought people would be probably a little bit more keener than usual. Saying that, I've submitted probably about 2 other petitions which I probably aren't going to bother collecting the signatures, because I realised that I might have made a mistake or error on them, right? But I don't think that 553 people did make an error. I think that it's more likely that 353 people have probably got the 5 signatures, and they might be the amount that they're just... I think that they're just not going to publish them, right? Because for whatever reasons, just for whatever reasons, there's a very, very small number of rejected petitions. I don't think 553 people would have abandoned them. So it's interesting figures. It's quite it's a very high rate of rejection, don't you think? To say that if there were 427 petitions submitted, right, and out of 427, only 63 have been published at that point, and that's the number they've got through checking all of the 427, and only 30 they wanted to actually officially admit that they're rejected, that exist. So I don't think that all that number of people actually have not bothered to get the 5 signatures, or like made a typo, or decided that they don't want to do it anymore. I think that what it reflects is, and these are all people who, everyone has been to school. We're not in the 1600s where people aren't taught to read and write. They can't write for themselves. They need a lawyer to write. A lot of people have been to school. They're educated in the English language. They can write for themselves. And then they're not that stupid, right? So it makes you wonder, what's going on here with this petitions committee? Because, you know, what's going on with this petitions committee? Because the thing is, right, this is the thing with it. If you like went to the supermarket, right, and you were selling boxes of screws, right, and you know, for every 400 boxes of screws, right, you know, 300 of them got returned because they were faulty, you would start thinking, what's wrong with these screws, you know? And if you go to court, right, I'd be interested to know, you know, that online small claims court online, the online small claims court, you can go online and you can claim money if someone owes you money. Although I think that the least thing that you need to use that for is money. I mean, people want to, you know, claim things that, you know, you're doing this and you're not meant to do it. You know, like YouTube, you know, taking my videos down and you're not supposed to, or whatever. You know, money is the least of our problems. People want to claim against people because they're not doing what they're supposed to do. You know, that's the point of a civil court. You know, why is it always over money? Usually it's over copyright. Have I got the rights or haven't I got the rights? It's not usually just about the money. It's about, you know, getting the fact that you agree they are my rights or they aren't my rights, or I have got the right or I don't have the right. This is the problem. I actually think it now is that they're actually taking away. No one can afford to go to civil court and claim all these things and pay for these lawyers. They're way out of our price range, and it's only other companies who have got money, successful, profitable companies who can sue other companies, and then all those companies have been bought out by BlackRock Vanguard, and then all the shareholder decisions are made by literally the same people in these networks of companies who will then all adopt the same policy and adopt the same staff training and adopt the same strategies across all the product brands and so forth. So it's not really companies versus companies anymore, because apparently, you know, these big shareholders, it doesn't really matter whether they sell Twixes or they sell Mars bars or whether they sell Fox's biscuits or whether they sell, you know, peanuts. If it's all the same companies who own it all, then it's just like it's just having like a big, you know, it doesn't matter who buys what really, you know, because, you know, it's all the same. It's just juggling. It's like Nancy Pelosi just juggling her shares around from one to the other. You know, Twixes are doing better this week, so I'll move my stocks to Twix, and then, you know, Babe Ruth's doing better the next week, and I'll move my stocks to Babe Ruth. But when, you know, it's juggling, but you've got all the balls. And therefore, I think that civil court, where you get an order where I'm right, you're wrong, is limited now to people who have got crazy money. I mean, look at Stonehenge Tunnel, £135,000. And what the public have been relegated to now for civil claims is, you know, if someone owes you a bit of money, or if someone owes you a bit of money and they haven't paid you for it, we'll give you a little quick way to get it back. But, you know, we're not going to give you a way to claim. Oh, actually, they have in America. They've done CCCB in America, which is like copyright claims. You know, if you want a little dispute over a video copyright, you can do it. But YouTube are exempt from copyright, so you won't be suing YouTube for it because they're not ever to be treated as another party. But yet you can't, you know, go through there and say, you know, YouTube, you know, I've got a legal right in law to do this, or I've got a legal right in law to do that, and they haven't, because that's not over money, is it? That's over the law. You're not claiming money. So in a way, all these phases of getting us out of access to justice or judicial decision making in the public. They removed us from the juries. You know, it's all like the councillors now make decisions for political parties and for executive branches of strategic planning of councils. The jury, the public can't randomly turn up and decide, right, you're not building that road there, or, you know, you can't build houses there. A random jury of 12 people, right? It's all political party strategy and executives in councils who make all the decisions, not 12 people from the local area randomly, fairly chosen. Or even for any claims in a civil court between parties who have got a lot of money, you know, and then these lawyers are on ridiculous money that no one can afford, except companies and businesses that have all been bought out and taken over. And what those companies and businesses do through their training is drill behaviours into people so they do as they're told, like on Star Trek Next Generation. And all these persons, individuals in companies who might not be aligned to this corporate objectives are weeded out, basically, you know. Or even if even if one of the factory owners or guys is opposed to what the other factories and brands are doing, it's trends, and they end up following these trends and manipulated into doing whatever. In fact, even in the pharmaceutical industry, some of the doctors have been saying that, you know, they've realised that, you know, what they're doing is wrong or not right, but a lot of them are under pressure. This is the whole thing with, you know, Fauci and things like that now. You know, this type of thing, we're getting people in these industries that are getting a bit more switched on to what's going on, and then this is the way the NHS has been orchestrated, and this whole pill pushing and so forth issue as well of one of those things. But anyway, so yeah, what was the point in that conversation? Well, that was about civil claims, like civil online claims, you know, access to law, access to justice, yourself, accessing it yourself. You can do it online, but they're limiting your access to money if it's about money, and not a lot of money. And the more money it is, the more and more the court wants from you, right? What I'm actually saying is that it's very, very difficult to prove something or get something officially proved through a court and get another party or another entity to agree with you. You know? Now, yeah, so these petitions, right? What are civil claims and civil online got to do with this petition? Well, what I was thinking is, and that was another long tangent of a conversation, going back to the civil claims. Why did I mention the civil claims? Because that website has got to have so many people using it, like every day or every week, right? And I was thinking, how, like, you know, whoever uses that civil online claims website is probably not going to be a big company, because big companies just go to court and get lawyers. They don't like DIY it online. It's mainly designed for normal people, like laymen, normal folks, like, you know, people who don't use massive law firms and companies. So it's got to be the same type of education and intelligence people who are doing the petitions website, right? Surely it's good to, like, average normal people, right? Now, what I'm wondering is, out of everyone who goes on that government civil claims website and submits a claim, which is to courts, to judges, to justices, you've got to write the claim out and you've got to say, you've got to make a case. I'm interested. This would be an interesting freedom of information to ask the Judicial Conduct Investigation Office, because they're actually subject to FOI, freedom of information requests. And that would be, how many cases were even submitted in 2024? Right? How many cases were submitted to online small claims in 2024? Right? And out of all those cases that were submitted, right, how many did they reject because they didn't know what the person was asking, or they didn't understand the claim? Not for what the person won the case or lost the case, right? You can submit a claim to a court and you can lose. You can submit a claim to a court and you can win, right? But how many were rejected and not even entertained because they didn't understand what the person was claiming for, or they couldn't understand it, right? And I would be interested to know those figures, right? I'd be interested to know those figures. Was it 50%, 25%, 10%, or none? Did they understand every claim and either the person won or they lost? Now, if the figure is extremely low, if hardly anyone had a claim where the justices didn't understand what they were asking, or if there was very few to little or none, right, and either most of the cases either they won or they lost, then that makes you think that most people know how to write like a case to an authority where they pretty much know what they're asking, or it's easy to see what they're asking, right? So wouldn't that make you wonder, why is it that the Petitions Committee and MPs, right, out of 493 submitted cases, only 63 were published and 30 rejected and given a reason why they were rejected. So it only looks like 30 were rejected. Now, if they actually did reject, if they actually truly did reject the other 493, if they did reject the other 493 petitions, then that would mean that 493 plus the 30, so about 400, just let me, 493, 353, unpublished, 353 plus the 350, 356, 383. So 383, got my numbers mixed up. 383 are actually unpublished. Now, if the government on the petition's website, if it actually told you that amount and that number, right? If it said that, well, actually, there's been 493 petitions submitted, and if they actually said we've published 63, but we've rejected 353, bloody hell, then people would be saying, bloody hell, that's a hell of a lot of petitions to reject and not want to publish. It's quite a lot. In fact, there's only a very, very small number that you even let run. And that's not even saying you'll debate them. They wouldn't even get a judgment on them. They wouldn't even get a judgment where you win or you lose, where the MPs vote in your favour or against your favour, where so many MPs vote all the ayes or all the nays, all the yeas or all the nays. If all the MPs vote on it and 50 vote in favour and 20 vote against it, then, you win, right? So you won your case or you've lost your case, right? Like, stop the ULEZ. Well, how many MPs vote in favour of stopping ULEZ and how many people MPs vote against stopping ULEZ. Well, you either win or you lose. That's if it gets heard, right? But it seems to be that it's a competition or a contest to even get it running. So you can even attempt or try to get your 100,000 signatures to compel them to hear it, or to give evidence that it should be heard, let alone show evidence, if it does get heard, that it's a strong case that the MP should vote in favour based on the evidence. Not on their debate, remember. The debate is only that the strong evidence gets heard and voiced. And remember, you're the plaintiff. You're the one bringing the case and trying to make the case, not the MPs. The MPs are supposed to debate the matter based on the strength of the case. Some vote... The MPs... all these MPs are the ones who compel the evidence and use the power of summons. It's a bit concerning because it's almost kind of like, if you went to a court, right? If you go to a court, right, and you want to prove that John owes you £5, but you're limited to what evidence you can attach, right? They say, oh, you can't write too much. So you can say, oh, John owes me £5. And they say, okay, then, well, John owes me £5. I gave him it last week and he hasn't given me it back. Okay, that's enough information. Okay, it's clear what you're asking. We understand what you're asking. You're asking for the money back because, you gave it to him last week, right? Now, can you imagine if you submit that case, right? And this is the thing. What Parliament are doing is it's almost kind of like the judges then are the ones who decide on, they've not let you really give much evidence, so they're the ones who will look for more evidence and deal with it. Now, is that kind of a little bit like, you've got, can you imagine if the duty solicitor was kind of like acting for you, but you weren't able to submit much evidence? So the duty solicitor and the prosecutor themselves decided that they were going to take it upon themselves to go find some evidence. But remember, it's your case, and you're independent, and they're members of certain political parties who have got certain policies and clauses anyway. Now, would you trust the duty solicitor to make a thorough good effort of getting really good evidence, given to the fact that he might not be fully helping you or in favour of your cause? You just happen to be lucky enough to submit the cause, right? Which wasn't easy, right? Because you had to get 100,000 signatures to do it. And the prosecutor was actually against it, right? Now, for the MPs who turn up at these committee meetings, who are, you've managed to get them into debating your cause, but they might not be fully against it, like some of those Tory MPs who were claiming to be opposing ULEZ, right? They were giving evidence like, these ULEZ schemes are no good. That guy Doncaster says, oh yeah, it wouldn't be any good for Doncaster, or we don't really like them, or this or that. And they're talking about ULEZ, saying that, the Tories were saying Theresa Villiers and Gareth Johnson saying, no, they're not that great, right? And then after the debate, then they vote in favour. They vote on it based on the evidence given. But what actually gets said is that the judge or the chair of the committee ends up saying, well, I now order all those in favour of, all those who what she effectively said, if I get it right, and I'll have to watch it back. I'll have to watch this back again, but we could get the video up. I'll make a separate video of that. But she effectively says something like, "We've debated ULEZ today," and then all those in favour of agreeing that we've debated ULEZ say yes, and all those opposed to agreeing that we've debated ULEZ say no. And seeing as only one Labour MP had turned up who opposed it, right, they all voted yes, because all the Tory MPs voted yes. And then they said, yes, and then she said, I now declare an order that today we debated stop ULEZ. And then she slams the hammer down. So she just made an order that basically said that they debated the matter. She'd ordered that they debated the matter, but they didn't say debated it to what verdict. And the verdict was actually that they debated it, which was kind of ridiculous. It was kind of, I just couldn't wrap my head around it. It was just so insanely ridiculous. Now, what evidence was presented was what the MPs had gone and potted around and gathered themselves. Like that guy from Doncaster MP was just saying that, yeah, well, I've looked into this and it's not really going to be any good for Doncaster. It won't help us. We don't like these ULEZ zones. They're no good. But what evidence is that to... It's kind of almost like... It's almost like going into a courtroom, right, and then having someone who's robbed a bank, and then rather than putting evidence there and saying, yes, he did it, and then saying, right, you're guilty, and then go to prison, it's kind of almost like the duty solicitor comes in and says, well, I've had a look around, and yeah, people don't like crime in this town. They're not too keen on it. We don't really want any more robberies in this town, and we're not too happy about them, and we don't think that robberies would be good for this country. We think robberies are bad. And then almost kind of like saying, the court going, yes, well, everyone think robberies are not a good thing? No, they're not a good thing. Do we all agree on that? All those in favour say yes, and all those opposed say no. And then, like, almost like making an order, then saying that, yeah, robberies are bad, right? And then actually, what the court order is like, we all agree that robberies are bad, and we shouldn't have them, right? But they don't end up sending the person who just robbed the bank to prison, because the evidence that he robbed the bank was not really given. But they potted around and brought their own evidence in, which was just generally about the general subject. It was kind of ridiculous in a way. And this is kind of like, it's almost like the reason why supposedly practicing attorneys are not meant to be allowed to be judges. Because if a practicing attorney is allowed to be a judge and work as a judge, then when he's working as a judge, when he's working as an attorney, it's like judges are deciding what evidence is brought into courts and how cases should be presented that better suits judges and what judges and the courts want, not what the claimant wants and the outcome that the claimant wants and what the objectives of the claimant are. And that's really the monopoly on the legal system and the law, really, at the moment. The claimant, the person who wants to prove something and get something done, they are meant to bring the evidence. Now, you get a lawyer to help you because he knows the law, but you direct the lawyer, you direct the solicitor. And I think this is the difference between like the police and the Crown Prosecution Service, and you bring in a prosecution privately. It's like having a monopoly on law, monopoly on justice, rather than, the citizens actually deciding what cases to prosecute and what evidence should be laid. And this is the thing with civil cases. If you want to win a civil case, like that Stonehenge Tunnel case, right? They brought a hell of a lot of evidence and they had like 8 barristers, but those barristers are meant to know the law and they're meant to know which legislation and acts to use and what arguments to make, but they're meant to know what arguments to make based on the claim. And they can go and get more evidence, and they can go and request more evidence and documents, but it's with the claimant. And really, the thing is that I don't even know if an MP in a committee is the equivalent of a duty solicitor or not. Because the MPs are all meant to kind of be equal, and the thing is that the chair of the committee, and when you have like a chair, in these committee sessions, you have like three ministers who are like the chair, like three magistrates, right? They're appointed to basically they make sure that everyone speaks and organise it all like a court, right? But they make the order, and after they've made the order, they're meant to go tell the speaker that they had a hearing and they made the order. Like it's like a mini. It's like the sessions in. The thing is, in open parliament, right? You have sessions, but sometimes it's empty and hardly any MPs turn up, but they're still doing stuff, right? The committee meeting is almost like that, but in a small room, so it looks fuller, right? And they make a decision, and when they've made a decision, they go tell the speaker, and then the speaker's meant to go put it through officially, you know? Really, that's going to be what it's like, as far as I can gather. And the problem is that this is the thing, right? The MPs in the committee, or at least in the type of committee when they're voting and an order's made, right? All the ayes and all the nays, all the votes, right? They're voting, right? They're voting. They are making a decision in favour or against. That is the juror's job. In a court, the jury vote. If you don't have a jury, then the magistrate decides, right? Now, in the committee, they appoint some of the MPs as the equivalent of the magistrates, and the rest of the MPs, the ones who vote on it, yay or nay, like a jury, and then the three on the panel then hit the hammer down and make the order, right? Now, this is the thing. In a courtroom, the duty solicitor isn't the jury. He doesn't get to vote guilty or not guilty. He presents evidence. And the Crown Prosecutor cannot decide who is guilty or not guilty, right? They can both present evidence and make a case for or against. Now, this is the thing. In the committee meeting, you've got someone has to present the evidence and make the case, and they debate it, right? They can give evidence, but the evidence comes from the claimant, right? Which they've submitted, but they can also get more evidence. But the thing is that the whole thing is kind of being orchestrated. You've got a claimant and you've got a public gallery, because the public can, you know, like Tess Lowry sat there because it's her petition, and she collected the evidence and submitted the evidence and facts of the claim. And that evidence also is 116,000 people's evidence of public concern. Could have been more, could have been 3 million. But also, she submits documents and evidence and so forth. But in court, if Tess Lowry went to a civil court to prove X, Y, or Z, or that, you know, the World Health Organization shouldn't, you know, dabble with our rights or whatever, right? Then if she could get a lawyer, but she and her lawyer are working together as one unit to bring evidence, to get evidence, and then to make the case to the court, right? Your lawyer works with you as one body, really. They're just learned and experienced in the proceedings of the court, right? I mean, you can go to a lawyer and know nothing and say, can you help me? I've committed a crime. Can you prove that I'm innocent? But they question you. They ask you for evidence. If you've committed a crime, right, your solicitor doesn't, you don't sit there in a chair like a dummy and do nothing. Your solicitor just doesn't go off and research. He's already meant to know all of the law around all of the things. But he needs material. Law's no good purely on law unless you're just arguing the law itself, right? Which you can do that. You can just argue legislation over legislation, purely only having acts of law in front of you using logic, right? You can do that. But usually if you've got a case to bring, it's usually about something that's happened somewhere or somewhere around, right? Now, if you've been accused of a crime, right, the solicitor just doesn't go off and grab things like, I don't know, evidence, jackets, statements, things of his own accord. He asks you, what did you do? You give me a statement. I'm asking you. The evidence is coming out of your mouth, right? Where were you on Tuesday? Can you prove that you're at the seaside? Tell me this, tell me that. Explain what you meant about this. Explain what you're feeling about that. It's you. Did anyone else see you? What are their phone numbers? Let's go see them. Let's get a statement, right? It's all evidence coming from you. You're the client. You're the person with the problem. You're the person with all the information, right? You go to him because he's an expert in that law and he already knows all that law, right? There's nothing more for him to learn. Every bit of information about the case is from you. You are the information, right? Now, when you're wanting to get a law made or changed, everyone's meant, in Parliament, they're meant to already know all of the legislation, at least to the proficiency of a lawyer already knowing all the law. But why you should get the law changed or why you want the law changed, anyone can have the law changed in any way they want. But you are coming saying that we, right, me and these people who have signed it, want the law changed to this or that. But why? Why should we do that? Well, the political parties have already got their own agendas and manifestos, whether they support it or oppose it, right? But the more evidence that you bring and lay proves to those MPs why they should vote in favour of your request. Now, if the MPs' parties already have a position on it, they're unlikely to go out of their way to get more evidence to prove their own party or themselves wrong. It's you, the independent person, who is laying the evidence to compel them to vote in your favour. Now, that's like going into a court on a table and getting the jurors to vote in your favour, right? But if you are restricted on what evidence you can give other than a massive amount of people supporting it, you can have all the people on the planet supporting it, but it might not prove them to vote in your favour or not, you know? And there's something very troubling now in my mind that I've got about this difference between the MPs voting yay or nay in favour or against it when they're the ones who are each of them giving some evidence. Because that's like the juries themselves giving evidence, but then the juries themselves voting, which is when particularly half of them already are in a particular party that opposes it, or half of a party that particularly supports it. It's odd. And surely what they debate, therefore, cannot be purely... You can't have a jury. You can't have the jury. You can't come into court and say, "Excuse me, I'd like to file a case. I'd like to prove, that I'm guilty or not guilty or, this or that. And then the jurors go off, and the jurors are the ones who get the evidence, and then they come back, and then depending on what evidence they've got, then they're the ones who decide whether you're guilty or not, because they might just can't be asked to get decent evidence, or some of them might get evidence strongly against or for, which you're the person who submits the case, and you're the person who brings the evidence. And the MPs are kind of... they've got a hybrid position, which is somewhere between a duty solicitor and a jury. But the thing is that they're mainly debating in the chamber, and they can compel witnesses to come, and they can compel evidence, but this is the thing, who's directing them? Because in a court, the person who brings the case, both the defendant and the respondent can give directions. And it's this is what we're arguing with the committee. Is this giving directions part? When you give directions, you can say, well, I've got this evidence, but I, the claimant, the plaintiff, the petitioner, I know that there's some very strong evidence here or there also, but I don't have access to it, or I'd like to get it. Can we have a warrant for it, or can we have a subpoena? This is the thing. And this is, also, how do you get the public to support it? Well, when they read the petition and read the complaint, they got to look at it, and they got to say, this is very compelling, I'm going to sign this. You wouldn't sign anything until you read the complaint. This is the thing. You won't put your name to anything and sign it unless you've seen the grievance, the complaint, the writ. And they're not letting you publish it on there if Parliament don't like it. We'll say, no, the case is too strong, or the case doesn't make Parliament look good, or this or that. We don't want people to sign that. Well, it's almost kind of like saying, don't vote for Labour. Oh, we don't want everyone to see this sign saying, don't vote for Labour or whatever. They're letting party politics get in the way of, and their party policies, manifestos get in the way of our individual cases. It's almost kind of like saying, it's almost kind of like saying, well, it is. It's like saying if you went into Congress, right, and you had a case to Congress that you wanted to make chocolate bars illegal, right, and Nancy Pelosi, the Speaker of Congress, said, I rejected this petition because I've got shares in Cadbury's, right? She's rejecting the petition because she doesn't want you to make chocolate bars illegal because she's got shares in Cadbury's, or the Democrats like chocolate bars because it makes them a load of money on the stock exchange. It's like that. That's how corrupt it is. That is the corruption of it. They're getting their own party's politics involved because they've got ulterior motives. And this is like in court if you had a Labour jury. If you had a Labour Party jury, it would be no good for a Tory. They'd be screwed. And this is the thing. This is why they removed the juries from magistrates' courts, and why they removed the juries from civil courts and from the council as well, from council matters, because they didn't want working class Labour juries to say, no, you're not building a biscuit factory, or no, Johnson's investment company Limited, who are assets of £20 billion, aren't building a new housing estate next to my house because I don't want it there, right? And why they started saying, Baron, Countess, Dame Theresa and Baron Munchausen have divorced, and they didn't want a Labour jury to say, fucking hell, that's all the money that we worked for in factories that the fleece from us, and now just because Dame Cricket's gone and shagged some Biggles pilot from fucking Kent, now they're splitting up and she's running off with £20 billion, which, just for having a shag, which is why all the factory workers have been working there fucking 8 days a week at slave labour, and they've got peanuts. And effectively, what they did is they made factory workers, they made factory owners, business owners, big corporate persons, they made them into peers, privileged peers, by removing the juries, because then privileged persons, big business people, didn't have to have poor people, right, judging them in court and what they can and can't do. But the real life peers, the privileged life peers, right, what the royals did is they said, they pretended that we're removing the privileges. They're removing the Magna Carta privileges, so then they can be tried by courts. But they're not being tried by courts because they removed all the juries from the lower courts. So they actually ended up they hadn't really. It's a bit of a con, a fleece, a trick. It's like a cup under the ball trick, because they said, oh no, they pretended that the peers don't have privileges anymore, right? When they can't be removed because of Magna Carta, but they pretended that we removed them, but really they hadn't, because what they'd done is they're never going to be judged by poor people, because poor people are removed from the juries. So even if Lord Hanningfield gets a speeding ticket, right, he's not going to be judged by a jury of working class people in a court. He's going to be judged by the magistrate, right? And even the magistrates, are fobbing off. I think even Suella Braverman got a speeding ticket. She was an MP, and they also got control of a lot of them as well through the courts. It is a con in a way. It is a con, because we've been kept poor without any money, so we can never really afford proper legal power when it comes to challenging, particularly these big platforms and these big companies when they're introducing these policies. Because what you really want to do in court is challenge them on their policies, like these ridiculous things like, we can do anything we want for any reason or no reason, which is just insanely false. It's untrue. It's a lie. But they're running big companies on this. Or YouTube, kicking you off and saying, we can terminate your account, even though it's not the law. You haven't broken a law. They're making policies up which aren't even the law. But the Public Meeting Act says that they can't break up a meeting unless it's illegal. Well, if you haven't broken a law, then how can YouTube break the meeting up? Because they're making policies up which aren't the law. They're just their own rules. But it's not private. It's privately owned, but it's not private because anyone can watch it and look at it and read it. So if anyone can watch it and look at it and read it, then it isn't a private place. So if it's not a private place, then, you know, they're trying to kind of, they're trying to legislate things where they don't have the authority to do it. And then also, if you actually are doing something under parliamentary privileges like petitioning, and you go to court and you challenge YouTube, they can't hear the case because it's legally privileged items of information. Illegally privileged items and information can't be used in evidence. So YouTube can't win a case in the county court over their policy, because if they wanted to challenge you on it, they can't do it. But who can challenge them on it when no one's got any money? Well, when you challenge them on it, but you can't really get them in court because you're privileged. So, and this is how Congress and Parliament are giving these 77th Brigade directions. They're giving these 77th Brigade directives and telling the platforms what to do. But the only thing they're not telling the platforms what to do is they're not telling the platforms to uphold our rights and privileges and freedoms. That's what they're not telling the platforms to do. They're not saying to the platforms, you can't have that policy, it's illegal, it's infringing people's rights and liberties, right? And that's what the oath was. The oath was to uphold the rights and privileges of the people. And they've removed that bit from the oath. So no MPs, no judges, no justices are upholding those fundamental liberties, which are still law. And this is how we've got this corporate platform rule, where Mark Zuckerberg pretty much thinks that he can do what he wants, just because he's got a load of numbers, which amounts to money. And they've got all these insane graduate students, lawyers coming out with these insane policies that are just non-logical and can't possibly exist because no one can challenge these people. No one is in that league with the amount of money they've got, you know. So coming back to the petitions committee, so what is the deal with the petitions committee? Well, the deal is that all the way through history, people were annexing, they call it annexing evidence to petitions. That's attaching evidence. If you don't have any evidence, you can't prove something, right? We know that. It's a case. You're trying to prove something. If you can't annex evidence to it, you can't prove anything, right? Now, you could go into it's almost kind of like going into a criminal court and you've got 500 witnesses who say that you're not guilty, right? But yet there's no piece of evidence, there's no exhibit other than witnesses, right? And all those witnesses say that, they think you're not guilty. But on what basis, right? And if you had 12 or if you had 100 witnesses who come and swear on oath that they don't think you're guilty, but there's no tangible piece of evidence, the evidence presented is purely witness statements, right? Now that means you've got 100 witnesses up against a jury of 12. And the jury of 12 have got no other evidence in front of them. There's no video, there's no fingerprints, there's nothing. Only people, right? Now, how is a jury of 12 going to stand up against 100 people who say one person didn't do anything, right? In a way, that's kind of how they're running the petitions committee. They want you to get 100,000 people to say we should, change tampon tax, but you might not have any proof of, what is the proof on, on wages, on how many tampons are sold every week, on what the average profits are for the companies and what percentage of the companies make compared to other companies, and are these products even any good or not? Should people even be buying them? Is there any point in them? and many other things as evidence to justify why you should change the tax on something if people should, have a privilege of buying more of them at a cheaper cost, or whether it shouldn't cost them as much. There are lots of evidence facts that could be presented on many different things of it, but if you don't have that evidence, you're basing it purely on people saying, it's like a kid saying, I want a sweet. Why? Because I want one. This is it. Not any evidence